Well, hello everyone. Thank you for tuning in today. Welcome to It's Time for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, medical malpractice, trucking accidents, workplace injuries, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. More Injury Funding is a sponsor, member, associate, or business partner of this podcast, Academy of Truck Accident Attorneys, Sandy Spring Bar Association, Georgia Association for Legal, State Bar of Georgia, and Georgia Hispanic Chamber of Commerce. In today's episode, I have a very special guest, Attorney Rishi Patni with Bird Law Group based in Atlanta, Georgia. Attorney Patni graduated from the Florida Coastal School of Law in Jacksonville, Florida, with JD degree 10 years ago, and had received the BA bachelor's degree from the American University, Washington, D.C., prior to that with majors in communication, legal institutions, economics, government. Attorney Patni is a member of the American Association of Justice, shorter for an AHA, and the Georgia Trial Lawyers Association, GTLA, and a recent graduate of GTLA's Leadership Development Program called LEAD. Welcome to the program.
Thank you so much for having me.
Thank you for being here. It's an honor. So today, Attorney Patni will talk about the medical malpractice law. These types of legal cases are known to take so much longer than others to resolve and find justice. At the end of this episode, I'll have a fun pop-up question for our special guest today. So stay tuned in, my dear listeners. You are here for a treat today. So Rishi, welcome again to It's Time for More Injury Funding podcast.
Thank you so much. I appreciate it.
Well, let's begin our discussion about what is medical malpractice law.
So medical malpractice, it's an area of personal injury law, but it's specialized because there's a lot of unique aspects of it. It deals with personal injury that occurs as a result of professional liability from physicians, hospitals, clinics, and other professionals in the healthcare field. There's several unique features that make medical malpractices a little bit more unique and more complex from your average slip and fall or car wreck case. One of the first ones is obviously the complexity of medical science. Before you can determine whether or not medical negligence has occurred, you have to understand the medical science behind the medicine and the care and treatment that the patient received. So getting an understanding of the medical science and its complexities is an overarching part of what makes medical malpractice a little bit more complex and takes longer. Another aspect of it is the affidavit requirement in Georgia. So unlike most cases where a lawsuit can just be filed once you talk to an attorney and he understands what happened, for example, takes a look at an accident report, takes a look at the damages and the medical treatment, a lawsuit can be filed at any time. In medical malpractice cases, you have to have an affidavit that accompanies your lawsuit. And the affidavit has to be from a qualified licensed physician that identifies at least one act of medical negligence that they have to swear to. And that has to be filed with the complaint in order for a medical malpractice case to be properly filed.
Okay.
So that's one. And then the third area, of course, is the costs that are involved. There's a number of experts that are involved in medical malpractice cases, and they can be experts that deal with very small aspects of the particular case, or they can be overarching consulting experts. They can be experts on the standard of care. They can be experts on causation and also on damages. And so the number of experts involved increases the cost. The type of discovery that is required in medical malpractice cases also increases the cost, and those barriers to entry are often what sets apart medical malpractice cases from your average personal injury case.
Okay, and did I understand this correctly? Is that there is no statute of limitations for medical malpractice cases?
There are statutes of limitations. Absolutely, there are. It's kind of a complex question. It's not an easy one, but a general rule of thumb is 2 years from the date of the treatment that resulted in an injury, or in cases where medical malpractice leads to death, then it's 2 years from the date of death. There's also a unique, qualifier for foreign objects, for cases involving foreign objects left in the body, there's a 1 year statute of limitation from discovery. But then there's also things that we have in Georgia, like what's called the discovery rule, that changes, that can alter the statute of limitations. And then we also have a 5 year statute of repose that applies to all professional negligence cases. So that will also overlie, but a general 2 year statute of limitations is what we give as a rule of thumb for the majority of cases.
I wish I knew you a couple of years ago, Rishi, because I do know of actually a couple of people who had some foreign objects left in their body.
And for that reason, the 1 year statute of limitations is often what surprises most people. Most people understand that I have 2 years to file a lawsuit if I want to sue someone for personal injury. And that generally applies to most cases, most areas of medical malpractice. But for foreign objects, most people are surprised to learn that there's only a 1 year statute of limitations. And I can't tell you the number of times we've received calls from people where the statute of limitations is already expired, and they might even have a case that we're unfortunately not able to help them with. So keeping that in mind, the 1 year statute of limitations for foreign objects left in the body is very critical.
Interesting. Thank you so much. Now, tell me, please, are there any type of guidelines to follow that allow an indication of doctors might misdiagnose or improper treatment of one's illness?
There's a number of different guidelines. The one that is most important and the one that seems to be the central part of medical malpractice cases, it's the guideline that we refer to as the standard of care. Now, the legal term of art for standard of care, this is the degree of care and skill ordinarily employed by the profession generally under similar circumstances and similar conditions and like surrounding circumstances. What that really means is, what would a reasonable doctor do under the conditions that the patient was being treated under? That's that issue. That's the standard of care. It's not the law tries to make it objective, but there is a level of subjectivity to it.
Okay.
And so they're not bright line tests. They're often the opinions of experts that derives that. But other sources of guidelines are regulations, state and federal regulations, and also industry standards.
Can you give any examples for the state of Georgia as far as the regulations?
Sure. So for one area where we actually see a lot of an increase in medical malpractice cases involve the use of outpatient surgical centers or ambulatory surgical centers. And now there's state regulations in Georgia that we refer to as the 2359 rule. And what that requires is that after the 59th minute of the 23rd hour, the patient who's been treated in an ambulatory surgical center has to either be discharged home or transferred to a hospital. They cannot stay at the facility past the 24-hour mark. And so in cases where there's complexities or there's a complication that results in a surgical procedure at an ambulatory surgical center, what we're oftentimes looking at is, was the patient timely removed to a hospital or an ER facility out of the surgical center? We've seen cases where they've been kept at a surgical center for well beyond the 24-hour mark, and the level of danger that begins to occur in a surgical center tends to increase with each hour that passes after that 24-hour mark.
That's scary. Now, tell me, how can your client know if his or her doctor, nurse, or any medical facility, is liable for the medical malpractice?
Well, the reality is that oftentimes patients don't know. They are, at the time that the care and treatment is being rendered, patients are often sedated or under pain medication. They don't always know exactly what happened, either leading up to a surgery or after surgery, and they don't realize that they may have been the victim of medical malpractice until after the injuries start to manifest, or they start to observe or feel the results of those injuries. Or sometimes a subsequent provider that treats them realizes that something went wrong and suggests it to the patient. That's oftentimes the first time that they realize. Compare that to your average car accident. Everyone knows as soon as they've been in a car accident, that's where the negligent act occurred, and the car accident that resulted in their injuries occurred. For medical malpractice, oftentimes the underlying treatment and what went wrong is often unknown at the time that it happens. And it's not until later on that the patient realizes that something might have gone wrong. So the need to follow your gut instinct and follow up on questions that you might have, things that don't seem right, things that outcomes that don't seem right. It's critically important because the clock is already ticking on the statute of limitations.
Very interesting. Always, so that's a lesson right there. Always follow your gut feeling. So quick question on, let's say if, there's a possibility for medical, mistreatment with the first doctor and the patient sees somebody else, following that first doctor, and the second facility, the second doctor oversees the issue. Who's liable, the first or second doctor?
Oh boy. I hate to use the lawyer's favorite default term. It depends, but when it comes to that, you have to really look at it because it really depends on where the first opportunity to diagnose the problem and to actually treat the problem, where did that opportunity occur? But then there's also times where one doctor's negligence could be mitigated by another subsequent doctor that observes it, that sees the red flags, that sees the injury manifesting itself, and then that can be missed as well. So now you have two instances of medical malpractice that combine together to cause an injury. And in those cases, both of the doctors would be liable.
Okay, interesting. Now, if your client knows that this particular doctor or facility misdiagnosed or mistreated her, can she sue them?
Well, you certainly it's a possibility, but it's not it's not as easy as going right to a lawsuit. There has to be a medical investigation. There has to be consultation of experts, and you need to have that expert affidavit. And those are all prerequisites to getting a malpractice case filed, which is why malpractice cases take longer to investigate, and they're more expensive to investigate because of all these steps that have to occur even before a lawsuit is filed and litigation begins.
The average case for medical malpractice in Georgia, time-wise.
Time-wise, you mean from beginning of litigation all the way through?
Yes.
I would say an average rule of thumb would be, of course, with COVID backlog right now, things are even longer. But I think even before COVID, it would be incredibly rare to see a case go from being filed to trial in less than 3 years. And I think now we are pushing past the 4-year mark, and oftentimes 5 years past the time of filing the lawsuit is not unrealistic because of the COVID backlog.
Okay. Now, what are the key elements that need to be proven in the medical malpractice case?
So like most personal injury cases, you've got to have an act of negligence or professional responsibility, professional liability, and that's a breach of the standard of care. And then you've got to have causation. So a doctor's negligent act has to actually cause the injuries that are resulting. And that's another area of complexity with medical malpractice because when it comes to injuries, there are many possible causes of injuries. And so not only do you have to show that it was the doctor's negligent act that caused the injury that you're suffering from, but you also have to rule out all of the other possibilities to show that you've got the causation that the doctor's negligent act more likely than not caused the injury that you're suffering from. And then, of course, the third element is damages. You have to be able to prove the damages that you're claiming in the lawsuit.
Okay. How does a standard of care play a role in medical malpractice cases?
Well, it's critical. This is normally the main area of contention amongst experts in a medical malpractice case. So the standard of care, the law tries to make it an objective standard. Medical science, they try to focus on the consensus of the medical community to make it this objective standard. But because it can vary, reasonable minds can disagree in certain circumstances as to what a reasonable physician would do. There's an element of subjectivity in the standard of care that makes it. So this is why experts are often, this is what they're battling over in a medical malpractice case, is what the standard of care was and what it required that particular physician to do under the circumstances that are involved in that case.
Can a client resolve a medical malpractice case on her own, or does she need an experienced medical malpractice attorney for it?
We certainly wouldn't recommend it. A lot of the complexities that we've talked about, but it's very rare for medical malpractice cases to settle before litigation. And that is both a result of who you're dealing with, right? in medical malpractice cases, doctors and hospitals are covered by insurance policies that are a little bit different from your auto policy or your homeowner's policy. These professional liability policies have what are called consent provisions, and because a malpractice lawsuit can affect a doctor's reputation because it's recorded with the licensing board, they have to actually give consent for a settlement that's made on a claim. So the insurance company, unlike your auto insurance company, they can settle if you get into a car wreck and you're at fault. Your insurance company has the right to settle the case whether you want them to settle it or not. Now, on for a doctor, his insurance company actually has to have the doctor's consent, or the hospital has to give consent to their insurance company to settle the case.
So you kind of actually answered my next question, but how can your client prove medical malpractice? Can they at all on their own?
On their own, it's incredibly difficult. If they have the medical knowledge and expertise, if they have the ability to gather all of their medical records and perform their own analysis, it's certainly possible. It's not recommended. It's a very complex area. You have to understand the medicine behind it. You have to understand the nuanced rules that come with civil procedure and the time that they have to perform their analysis, get the affidavit that has all of the requirements to meet a valid affidavit, and then to get their lawsuit filed and in time.
So it probably makes more sense just to hire medical malpractice attorney, experienced one, and also some good experts, which you should say.
Absolutely.
Now, what are the major types of medical malpractice law areas that you most commonly come across and handle? Maybe misdiagnosis or failure to diagnose, surgical errors, nursing home negligence, anything else?
Well, there's different settings. Now, medical malpractice could occur at any point in the healthcare treatment regime, but there are certain areas that are often more susceptible to malpractice, and these include times of high stress, critical decision making, short amounts of time, where there's a lack of good information. So when you're talking about emergency room standards, you're talking about treatment by OBGYNs during birth and delivery, often in a surgical setting when you've got a lot of complex medical decisions being made all at once and requires the coordination of an entire team of healthcare experts to all perform at their peak in order to ensure a safe surgical procedure. And then a lot of times it's what happens after the initial procedure. So there are oftentimes things that occur. A surgery can go just fine and everything was done right, but then afterwards, a patient can suffer a blood clot as they're recovering from surgery, and that blood clot travels to their lungs and causes a pulmonary embolism, or travels to their brain. These are things that happen not during the surgery, but as a result of post-surgical care that is often critical, just as critical as what happens inside of the OR. So there's a number of different areas, but realistically, malpractice could occur at any point in the healthcare continuum, from when you are first consulting a doctor to when they actually treat you, to even after they treat you and then release you.
Okay. Rishi, could you provide some common examples of medical malpractice and how do they impact your patients or clients?
So common areas are oftentimes what happens when a patient undergoes some sort of medical treatment. Something happens during that medical treatment and it's not picked up on, because a lot of times there's this concept in medical malpractice. It's called risk of the procedure. Now, there are things where every doctor cannot guarantee a perfect outcome. And so there are certain risks that we know are attended with a particular type of treatment. So, for example, if you're going to a gastroenterologist, you're going to see that while they're performing their procedure, there is a risk that a portion of your colon can get perforated. And the fact that that perforation occurs is not by itself medical negligence. It's oftentimes the failure to identify the perforation and what occurs as a result of that leads to septic shock and a number of other healthcare complexities. That's where it's not necessarily the perforation itself. It's a failure to identify the perforation and treat that. So oftentimes it's what happens after the surgical procedure or the medical procedure and treatment.
Just stay if you can, of course.
Well, our primary area is practicing in Georgia, but they do vary. They vary not necessarily with the medical science. The medical science is supposed to apply kind of regardless of state borders, right? It's the requirements for what a cardiologist is supposed to do in Georgia should be the same as in Alabama or Florida. So the standards of care, those transcend state borders. But what changes in medical malpractice cases are those rules by which the malpractice cases are pursued. So the real rules of procedure, the rules of evidence, rules applying to expert, all of those things and how those cases are pursued through the courts is what changes from state to state. And that's what changes the nature of medical malpractice from state to state.
Okay. And are there any limitations or caps on damages in med mal cases in Georgia? What about other Southeast states like Florida, Tennessee, South Carolina, North Carolina, and Texas?
But I can't speak to all of those states, but I know that thanks to organizations like the Georgia Trial Lawyers Academy or Georgia Trial Lawyers Association, that does fight for our rights and our clients' rights at the Capitol. Georgia does not have some of the most restrictive restraints on medical malpractice cases that we've seen. Now, obviously, medical malpractice cases are the result of legislative priorities. And when you have legislative priorities that are advanced by proponents of tort reform, they're doctors and insurance companies that protect doctors are often some of the largest proponents of tort reform. They do not want to see these cases going to trial. They do not want to see these cases being put before a jury. That access to civil justice requires powerful advocates like GTLA fighting for your client's rights and they've done a fantastic job in Georgia, but they've not been as successful in other states. For example, South Carolina has a cap on non-economic damages. There's other limitations in Florida that make it much tougher to pursue civil justice in medical malpractice case.
Now, what types of damages can be sought in a medical malpractice case, and how are they calculated?
So in much the same way as most personal injury cases, you're going to have past and future medical expenses. Those are your special damages. Lost wages are also an element of special damages. Then you have your non-economic damages, your pain and suffering, things that you went through as how it changed your life. And those are oftentimes the most significant in any medical malpractice case. The level to which a patient who has suffered medical malpractice and the way that their life changes as a result is often the most significant aspect. And then in certain cases, not often, you also have punitive damages. Now, one of the limitations in Georgia that we have is a $250,000 cap on punitive damages in most cases, unless you've got intentional conduct, which is a very rare circumstance, thankfully. But those are generally the categories of damages that are recoverable.
And how would you describe intentional conduct?
Intentional conduct would be a doctor who's actually trying to harm his patients. These are actually the circumstances that podcasts are made out of.
Now, do you have or can you think of your most memorable med mal case up to date? What did you learn from it?
It's the first case that Alex and I tried together. It was an ER negligence case down in Henry County, and what I realized is that the standard of care that applies in a particular case is what makes or breaks a client's ability to recover in a medical malpractice case. It was a very difficult case to try because ER doctors have a different standard that you have to prove. Rather than having regular negligence, you have to prove that an ER physician actually was grossly negligent, which when the defense explains it, you have to be more reckless than the reckless doctor or more careless than the careless individual. That's a much higher standard to prove than just what a reasonable doctor would have done under those particular circumstances. That was a very defining characteristic and an appreciation for how difficult that case was to try. Now, fortunately, we were able to settle with one party. And so our client, after that trial, which resulted in a defense verdict, our client still had some recovery from the settling parties. They didn't walk away with nothing, but gaining an appreciation for how difficult medical malpractice cases are to try. That was definitely an eye opener.
It's amazing. And you mentioned Alex. Is she your law partner?
She is, yes. Alexi is. She opened the firm. She's started the firm from her mentor, Bill Bird. That's who the firm's named after. He ran this practice for about 40 years before his retirement, and Alex was his protege.
That's wonderful. And a truly great story right there. I would love to spend so much more time with you, but our time is running out. And so I have, like promised, this one pop-up question. You ready, Rishi?
Absolutely.
Okay. So what was the last thing you Googled? And be honest with me now.
The last thing I Googled was more injury funding. Actually, I knew that you and I would be talking today, and I wanted to learn more about what it is that you do and more about your operation. And so that was actually the last thing I did Google was more injury funding.
Well, thank you. I feel honored. Thank you. Hopefully it was, provided some information on there.
It absolutely did. It's very informative.
Excellent. Excellent. Well, again, that was Attorney Rishi Patni with Bird Law, and we talked today about medical malpractice law in Georgia and how it compares to some other southeastern states. We talked about its complexity and types of these cases, main causes and damages of med mal law. Now, Rishi, can you tell us if, God forbid, anybody, has a family member who passed away or somebody who has been really badly injured and they need to reach out to you, how can they find you?
You can find us online. You can Google Bird Law Group. That will take you to our profile. You can submit details of your claim through our website. We're also on Facebook and also on Instagram.
Okay, wonderful. That was again Attorney Rishi Patni with the Bird Law Group, ladies and gentlemen. And I want to thank you all for listening to our story today. For more tips and tricks on legal funding and personal injury law related topics, follow me, like, download, and subscribe for It's Time for More Injury Funding podcast on several podcast platforms, including but not limited to Spotify, Amazon Music, Apple Podcasts, iHeart, Google Podcasts, and others. And follow us at More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Yelp, Google Business Profile, and my website at www.moreinjuryfunding.com. I can't wait to see and hear you, my dear listeners, at my next coming episode soon. Until then, be well. Thank you again so much.
Thank you so much, Laura. I appreciate it.